He has not told us what you're going to do with that. What are you planning to have on that in that place? What are you planning? What is your master plan with
Well,
regard to
that has been stated in the affidavit itself.
where?
Details in page 56 probably, my lord.
No,
56.
Page 56.
56 is something else. 56 is something else.
That is proposed
That
plan.
pertains to proposed tree species to be planted and their location.
Yes. So no. What about this? What are you planning to have out there in that place?
In the place
Yes.
where the trees will be felled.
Yes. Yes. What are you
Yes,
planning to
Malad,
have?
that has been stated in page 56.
What is your master plan? What are you proposing? Just the road. That's all.
That's all, Malad. Just
And
widening of the road. And
and for
that also limited to 14 feet. Malad will kindly come to page, paragraph 2, page 29 of my affidavit.
yes.
That this deponent begs to state that the Assam Rifles on 8th of September 2025 handed over approximately 17 hectares of land at Lamual, Aizawl, to the government of Mizoram. Thereafter, the government of Mizoram initiated measures for integrated urban improvement and public utility development in the aforesaid area with the objective of addressing long-standing issues relating to traffic congestion, public accessibility, civic amenities, and urban infrastructure within Aizawl city. Accordingly, a master plan was prepared indicating that more than 60% of the total area would remain as green and open space, and the remaining portion would accommodate public utility infrastructure and civic amenities. It, it is
That
to
is
be
what
mentioned here.
it is not talk. It talks also of this thing,
Well,
utility structure and
yes,
civic amenity. What are these?
and the green area also.
Maybe,
And the
but what
green
are
area.
these?
That
What is this?
60% of the area will be open and green area. Now, my lord, with regard to the planning hereinafter, it is to be mentioned here that an advisory committee was constituted for planning and development of the vacated Assam Rifles area. And the said committee included the representatives from political parties, civil society organizations, environmental groups, including Center for Environment and Social Justice, and government departments. Thereafter, my lord will kindly come to paragraph 3, that this deponent begs to state that as a part of the urban redevelopment, the western edge of the vacated land taken over from the Assam Rifles, adjoining the existing main road from Bazar Bunkon to Treasury Square, covering approximately 665 meters, was proposed for widening and improvement of the existing road infrastructure to maximum 14 meters, whichever possible. In the third meeting of the advisory committee dated 16th of October 2025, the proposal for widening the road and the associated infrastructure works was deliberated, where the representative of CESJ were also present. It is to be mentioned here that the road improvement work involved modification of existing retaining walls and limited felling of trees situated along with the proposed alignment. So, my lord, this is the plan. It is not a huge work.
No,
It
no.
involves only 665 meters, and that too for widening, and the rest 60% has been kept as an open area and for plantation of greeneries. And the plantation, how the plantation will be made, what will be the exact plan for the plantation, that is stated in page 56 of my affidavit annexure 9A. That has been detailed as per your lordship's direction. The approximate size of the seedlings, the number of trees, the species to be planted, that is the botanical names, and the species to be planted, the local name. Everything has been stated in form of a chart as per directions of your lordship dated 18th of May 2027, 2026. So, my lord, this is a clear picture. Nothing relating to environment.
You see, there is one another aspect.
Lordship.
You see, you are going to make some public utility infrastructure and civic amenities. Now, would this also entail cutting of additional trees?
My lord, the list is there.
No, list might be there. This is a question, direct question asked to you. With regard to this public utility infrastructure, civic amenities, when you start building that, are you going to cut some more trees?
No. Whatever has been stated in the affidavit, nothing beyond that.
Nothing beyond that.
beyond that.
Nothing beyond that. So, as per this, you have said that another 23 trees to be felled.
Only 23, my lord.
For the
And
requirement.
how big are the trees?
Lordship.
Is there no way of saving one or two or three trees out
My lord, we will try our best. That much I can say. I most respectfully submit before your lordship that whatever will be possible, the state of Mizoram will take utmost care to save some more trees if it is possible. We will definitely try to do that. That is my statement. My statement can be recorded, my lord.
TJ Mahanta, yes, anything?
Yes, my lord, your lordship kindly see, my lord, let's say there must be a, my lord, less number of, my lord, destruction in the name of widening of road. Because there is a notification of the Mizoram government, my lord, that is page 42, your lordship kindly see. That notification start from page 39. There is a notification, my lord. So I just worried about that too, my lord. Page 42, your lordship kindly see.
Yes.
Page 42.
Yes.
The clause number 6.
Yes.
Felling permission shall be restricted to the least number of trees required to be removed from purpose. It should be, my lord, always, my lord, required. Now they said that only 23 or more has to be full. But if it come down, my lord, if it possible to save another 2, 3, 4 trees, my lord, who are very old.
Yes.
Because that is their guidelines, my lord. And that is one, my lord. So minimum discussion in the name of widening of road, that there should be minimum destruction should be done, my lord. That is my first pair. Second pair is that, my lord, clause 9, your lordship kindly see.
Yes.
That authority concerned will undertake responsibility of planning suitable trees specify where leo of the tree which be fallen, which are cutting. So that has to be by planting, not will purpose will not serve. They have to maintain it, they have to look after it, my lord. So that is my submission, my lord. Because today they will 2000 plantation they will done, but after 2 months they will find hardly 100, my lord. So that has to be looked into, my lord.
I agree,
That's correct.
I agree to my learned friend's submission, my lord, and steps shall be taken to ensure that clause 6 is looked into, clause 6 is taken care, and maintenance.
Exactly, my lord.
Maintenance will be there, my lord.
Exactly, my lord. And they may be minimum.
We are also concerned about the environment, and
yes,
we will ensure that the environment issue will be taken care of by us.
Another thing, since you have said that besides the 23 trees, no more trees will be cut for the public utility infrastructure and civic amenities. Can you give us his writing? Then we can finish off this case next week.
My lord, it's a statement by the Advocate General.
Maybe. No, we will record your statement now, but we want it we want it also, because they will say that this, we want to ensure that the government sticks to its word.
My lord, when it is a statement of the AG, my lord can be rest assured that the state, that is binding on the state government. It is binding on the state government.
Correct.
When the AG makes a statement, it is binding on the state government.
You see, because they will say that let it be there. You see, the other things are involved, public utility things. So we want it to be clarified in black and white. So since you are saying we will record your statement now, you file an affidavit, and next week Tuesday we'll take it up for disposal. And I think my brother Sanjeev will also be here in Aizawl. So both of us will be here in Aizawl and we can do it.
Matter could have been disposed of today, my lord.
No, how does it matter?
As per your lordship's direction, I can give an undertaking later on, my lord. The state government can give an undertaking later on.
No.
But
Later
the
on,
matter can be disposed of, my lord, on the basis of my statement.
No. Let it be. Let it be on Tuesday. We'll fix it on Tuesday. In the meantime, we just make a small affidavit. Another thing is, we have noticed in your meetings that you have had with the authorities, Forest Department was never a party. Forest Department, you had the ACS.
Forest Department was very much there, my lord. Lordship
You
will
had
kindly see.
no. You had Chief Conservator of Forest.
Lordship will kindly see
Ah.
that in page 57.
57, yes.
Page 57. No, my
Yes.
lord. No, my lord.
57,
Page
no,
55.
Forest.
Page 55. Page 55, Annexure 9.
Page 55,
This
yes.
particular letter, furnishing of report in respect of PIL so and so regarding felling of trees at Lamwal. Kindly find enclosed herewith with a joint inspection report in pursuant to minutes of meeting by mentioned above, para 1 under decision taken, where the said inspection was conducted as stipulated Annexure 1, and also kindly find list of trees felled and proposed to be felled as reported in the joint verification conducted on
No,
12th
that is
of
all
May.
right. That is all right. It is
Well,
by
this
the
is signed by the
DFO.
forest. This is signed by the Forest Department.
By the DFO.
Yes, my lord, the DFO.
DFO, you see, nowhere have you already taken the Forest Department into consideration. And this is, I thought that you will have a high secretary to the government or something at least.
Lordship
This
will
is a
see also
DFO.
that. Lordship will kindly come to page 53 also. The decisions taken. And my lord will see the paragraph number 2.
DFO.
DFO. Again,
is on.
DFO. And who is,
Shall
let us
submit the
see,
inspection
you
report.
have got additional secretaries, you have got joint secretaries, and you have got a DFO. He's not even a member. Just look at page 52.
My lord,
Look at page 52. You have got a ACF only out there at number 5. You don't even have a joint secretary. You don't even have a deputy secretary. You don't have a secretary. That no one.
Lordship, the issue was taken up on the basis of a guideline which was issued by the Forest Department. My lord, I have earlier also pointed it out, and it is here in my affidavit also. It was on the basis of the guidelines. My lord will kindly come to page 38 and 39.
Ah. Yes.
This is the notification dated 26th of September from the Government of Mizoram Environment, Forest and Climate Change Department. My lord will kindly come to section 2, subsection 4, page 40. The relevant page is page 40. Permission shall be granted for felling of trees which are dead, wind fallen, standing dangerous to life and property, and those which are required to be felled for the development of infrastructure. So this is a clear guideline of the Forest Department.
Guidelines.
Which we are following very meticulously.
When you look at these guidelines vis-a-vis the judgments of the Supreme Court, you'll have to see it's slightly different. Now we will take it up on Tuesday. You just file that small affidavit. On Tuesday, we'll finish it up. We'll decide.
As your lordship's direction.
Yeah.
But
On
the statement of the AG would
No,
have been
maybe.
reported, which is binding, on the government, my lord.
Maybe. But then we want that everything should be there in writing. Okay, right.
As desired by your lordship.
Third, Mr. T.J. Mahanta, learned senior counsel, and Mr. B.Dev, the Advocate General, Mizoram. We have perused the affidavit filed by the state respondent, wherein they have taken a stand that only 23 trees need be cut for widening of the road and also for construction of the public utility infrastructure and civic amenities mentioned in para 2 of the affidavit. Mr. Biswajit Dev, the learned AG, submits that. He gives an undertaking that no trees beyond 23 trees would be cut for road widening and to accommodate the public utility infrastructure and civic amenities mentioned in para 2 of the affidavit submitted by the state of Mizoram. Then Mr. T.J. Mahanta, the learned senior counsel for the High Court, submits that in terms of the notification dated 26/9/2017 at clause
6.
6 bracket, at clause 4 bracket
6.
6 and 4 bracket
9.
9, permission for felling trees should be restricted to the least number of trees required to be removed for the purpose. And that the responsibility of planting suitable tree species in lieu of the trees for which cutting permission have been granted would have to be the responsibility of the authorities, or the state responsible. Next paragraph. Mr. B. Dev, learned AG, submits that the state government will ensure that no more than 23 trees will be cut, and they will also see if another 2-3 trees can be saved during the said exercise, if not more. He also submits that the state government will ensure that after planting of the trees in lieu of the trees cut, the government will take proper care for the trees to be cut, but trees that are to be planted. So, on considering the submissions made by the counsels for the parties, we are of the view that the tree saplings which are to be planted in lieu of the cut trees should be not less than 3 feet in height. Say 2.5 to 3 feet, not less than 2.5 feet.
But that has been mentioned
Ah,
in page 56. These are all 3 to 4 feet.
okay, very good. Page 56.
Page 56.
Page 56. Annexure 9A.
Acha, should not be less than 3 feet. Huh?
Not less than.
Then, as has been enumerated in the annexure to the letter dated 21/5/2026 issued by the DFO, Aizawl Forest Division. Then what else?
Maintenance, I think.
The maintenance, the Aizawl Forest Division and the concerned PWD and other departments, UD and PA, should ensure that the planted trees are maintained. And if any of the planted trees die at any time, the same should be replaced by a new tree sapling. Full stop. On considering the above, though we are, yes, so what should we do, brother? We should dispose it of or what? Or affidavit?
Since Learned AG has very reluctantly agreed to it, let us have it on Tuesday again. Let them
Okay.
file it. Yes.
Let them file, On considering the above, on considering the fact that the issue pertains to development and as the state government has taken a stand that only 23 trees need be cut for the said purpose, we require the state government to ensure that an affidavit is filed in terms of the undertaking given by the AG, Mizoram, to the effect that the public utility infrastructure and civic amenities to be accommodated in the Assam Rifles land would not require the cutting of any other trees. List the matter on Tuesday,
Second of June.
2nd of June. So that they'll have time to file, at least within, by Monday they can file. Is it enough time, Mr. Biswajit Dev? Mr. Dev?
Hopefully it should be done because it's a
Okay.
short,
Short,
affidavit.
Short affidavit.
It will be limited to the only one particular issue, that is the undertaking.
Yes.
That
That's
not
all.
more than 23 trees will be felled.
Yes, yes, even for that public utility.
And that the maintenance will be taken care of.
Yeah, yes, okay.
Deeply.
List the matter on.
Maybe a
Okay.
bit.
Good.
Yes, any mention?
It is a lot. But as regard item 27, my lord, I am appear on behalf of the respondents, my lord. There is a appeal against acquittal, a leave petition has been filed, but we are seeking 3 weeks time to file our objection to it, my lord. I had the consent of the senior standing counsel CBI.
All just prayed for by the learned counsel for the petitioner, respondent, and with the consent of the learned standing counsel CBI. Is the matter again on when?
Let it be a little longer, my lord. He is in UP, my lord.
Longer after 12.
Can it be after vacation, my lord?
Depends on what she has agreed to.
Let it 3 weeks I have indicated to her. Let it be before vacation, my lord.
Immediately before vacation.
Yes. Deeply obliged.
Wait, please, Your Lordship. I beg to mention item number 26, prayer for adjournment. We have taken consent from the other side. A short date may be given, Lordship, next week. Thank you. Obliged.
Wait, please, Lordship. Would you consider the other side? I'm from the respondent. I would like to mention item number 12 of today's list. Can it be fixed after vacation, Lordship? For the respondent. I've taken consent of the is present.
Give the date.
For a date, my lord.
Give the date.
After vacation, I need it.
Much obliged.
Deeply obliged.
Please, Your Lordship, I beg to mention item number 20, Your Lordship. I pray for an adjournment, Your Lordship.
Yes, when do you want?
2 weeks may be given, Lord.
All right. Learned counsel petition. Just take it.
Obliged, Lordship.
Wait, please, Your Lordship. Lordship, I beg to mention item number 15, my lord. On the last occasion, my lord, CD was called for, perhaps it is not received, my lord. Not received.
List again on so and so. Remove the first earlier to continue. The next date of listing.
May please, your lordship. Lordship, I beg to mention item number 19, lordship. Service report has not been received till now. Let it come after 2 weeks, lordship.
This one, respondent number 2.
After 2 weeks, lordship.
19, item
Yes,
19.
item 19.
Round up. You know.
Deeply.
May I please, sir? Beg to mention item number 32, minor, from orders column, minor. Possible for the day, minor.
Item
32, minor, from orders column. Possible for the day, minor. Publish.
give a date. Date the delay.
Let it be possible for the day, minor.
What, you don't want a date?
No, minor.
Why not? Why not?
We have some difficulties, minor. It's okay, minor.
You have difficulty for the entire rest of the 2026. Don't make unnecessary submissions. Doesn't look good on your part.
Sorry, minor. Publish.
Lordship, I am appearing for item number 39, Lordship, bail application, Lordship. Lordship, in this case, notice upon respondent number 2 has not been served, and a scanned copy of the TCR has not been received as well. Lordship, await for the SR and reminder may be issued for the scanned copy of the TCR. I'll go record.
Service also not complete.
No, no, your Lordship. Notice upon respondent number 2 has not been served. Lord.
Third learned council. This one R2 not yet complete. TCR also not received. Issue reminder. List again on. Yes, when?
9th. Yes, your Lordship.
Yes.
Item number 1.
Please, your lordship. Lordship, regular bail application, lordship. Acquisition of
NDPS.
NDPS, lordship.
Intermediate quantity, lordship.
Intermediate quantity, lordship. Is more than 1 month in the judicial
Only.
custody, lordship.
CD will be required.
All right, CD.
Obliged, lordship. Obliged, lordship.
Lordship, kindly matter pass over for time being.
Or seated matter, lordship.
Charge sheeted. Let him come, maybe they will appear.
Please, Your Lordship, the regular bail application, Lordship. As per the FIR, Lordship, allegedly 5 kg ganja was recovered from the house of the present petitioner, Lordship. It is more than 60 years old, Lordship. Village man, Lordship, as your Lordships know that in the Bihu, Lordship, some ganja is also required to burn in front of the house as well as the outside, Lordship. And that purpose, he has kept some ganja in his house, Lordship. No criminal antecedent, Lordships. More than 60 years old local person, Lordships, he will cooperate with the investigation. Lordship may allow him to go on bail any condition, Lordship. He'll cooperate with the investigation. Lordship. More than 60 years old, 5 kg ganja, Lordships.
5.062 K. 5.062 K.
5 kg, Lordship. Commercial,
So intermediate quantity.
commercial quantity is 20 kg, Lordship. More than 20 kg.
Dhemaji, lordship, CD will be.
More than 60 years old person, Lordship. Almost 1 month is in custody, Lordship. Forwarding report, I have annex, Lordship, page number 12, Lordship. No criminal antecedent, Lordship. The case is
There is no criminal antecedent until you are caught.
Lordship, your Lordship will know that the ganja is also required in Bihu, Lordships. In Guru Bihu, Lordships.
This is from Dhemaji. What you are talking about Diffu then?
It's a surprising statement.
Lordship.
You're talking about Diffu.
No, no. No, Lordship, Dhemaji, Lordship.
He's a peddler. Okay, CD. Give a short date. Okay.
I don't know from
8 June.
Oh, like. May please, your lordship. Lordship, petitioner before lordship is behind the bar for the last 16 days, my lord. It is 60 days offense, my lord. Maximum punishment up to 7 years, my lord. And in the case of criminal bishop present sitting as well, my lord. Lordship, may kindly see the FIR annexure 1 page 11, my lord. Translated copy, my lord. The complainant is from my lord, Nepal, my lord. They travel all along from Nepal to Namaji for purchasing gold, my lord. Nothing has been recovered from our possession, my lord. The FIR has been lost, my lord, for recovery of money, my lord. And in the FIR, my lord, the quantity of gold, alleged gold that has been delivered by the petitioner has not mentioned in the FIR as well as in the forwarding report also, my lord. This has been made from the positions as produced by the complainant, my lord. But you may kindly see the seizure list, my lord, and except for page 22, my lord. And one more interesting thing is that, my lord, as per the contention of the FIR, allegation of FIR, the alleged delivery of the fake gold is on 2nd May. But the FIR has been lost on 12th May, my lord. After 10 days, my lord. And no explanation has been given in the
What
FIR.
delivery of what?
Delivery of gold, fake gold, alleged fake gold, my lord. Let me kindly see the content of the FIR, my lord, in page 11, my lord, on 3rd paragraph, my lord. After the Rupa Singh had again called me on 2nd May 2026, Saturday, and gave me fake gold after receiving 3 lakhs. And at that time, there was one female, 3 male persons. I had given 3 lakhs to Rupa Singh, my lord. And FIR has been lodged on 12th May, my lord. And he traveled all along from Nepal to Dhemaji, my lord. And no notice has been issued, my lord. No, it is a rule, my lord. Laid down by the Honorable Apex Court in a certain document until, my lord.
You know, you have to see the CD whether it was issued to
My
you.
lord, my lord. From the contents of the FIR. 10 days, my lord. After 10 days. He waited for 10 days, my lord, for recovery of his money. And on 12th, he lodged an FIR before the police station in Dhemaji. The last part of the FIR, my lord, he stated that I use the such incident should not happen to any other person. That is why I have handed over the fake gold at the police station. I request the Assam police to help me to recover my money.
Of course, he will say help you to recover the money. Who will not say that?
My lord.
That doesn't mean turn it into a civil case.
My lord. Police will have 2 days police remand and thoroughly integrated.
How many days now?
My lord.
When were you arrested? 13.
13, my lord. 13/5, my lord.
So that's 2 weeks.
2 weeks, my lord. 2 weeks. 16 days, my lord. He had
Let me
thoroughly
short date.
integrated, my lord.
8.
FIR at page number 9, Lordship. It is
Section.
Annexure 1, page number 9, Lordship. POCSO 6 is there, Lordship.
Should go to.
Kindly,
Yes.
wife lodged the FIR against the husband, Lordship.
Hmm?
Wife lost the FIR against.
Who is the victim? Daughter?
Daughter is victim.
Then?
6-month-old daughter. Lordship.
It's notice to respondent.
Your lordship.
Is here. Scan copy of this.
But I take your lordship page 80. One police officer has lodged the FIR on 14/4/26 with the allegation that and get out our office, my lord, with the allegation that I have cheated some person in the assurance of giving job in the Bajaj Finance. But in fact, my lord, we have so many person have approached us. We wanted to appoint some commission agent of the Bajaj Finance Commission. And these 8 persons, those who assemble in their my office with their documented evidence, then PAN card, etc., police get out, then arrested all the 8 persons. And we are behind the bars since last 45 days and seized our PAN card, etc. And regarding my lord 35(3), which was not applied, my lord, because ordinance command has not been applied. The note, there is a note in page 24 by the Deputy Superintendent of Police. The notice under section 35(3) BNSS has not been complied, as the accused persons may commit a similar offence and also may not cooperate with the investigation. They evade the arrest. That is the allegation has been given, my lord. Not to follow the ordinance command, my lord. I leave it to your lordship, my lord.
Complex to grant without the CD.
But your lordship
Right,
will not
so
consider
lords-
that 35(3) has not been complied with
Don't
the
know.
apex court judgment, my lord.
We can only
CD
find out from the CD
CD.
how it has been complied with or not.
I pray for short date, my 45 days already, 60 days is mandatory period.
When?
10th. All I could know. 8th. Obliged.
May I please, Your Lordship? 482 application, my lord. The case has already been succeeded, my lord. What happened in this case, my lord? Lordship will kindly come to the FIR. Lordship will find at page 13. May I read, Lordship? Page 13, Lordship.
Yes.
With due respect, I beg to state that yesterday, on 16/12/2022, at about 9:30 p.m., it was informed that my daughter, Bina Rani Das, wife of so-and-so, has died hanging by herself with a rope in her rented house situated at Thanamukh, Madhuban Nagar, Jalukbari. Later, it came to light that before her death, my daughter had written a suicide note wherein she clearly mentioned the names of the following persons as being responsible for her death. Moreover, there is a suspicion that some conspiracy may also be involved behind her death. It has also been learned that due to the physical and mental torture inflicted upon her by her matrimonial family, along with demand of dowry, she was compelled to commit suicide, my lord. That was the FIR, Lordship. Lordship will find 3 persons have been named in the FIR, and petitioner before your Lordship are set serial number 2 and 3, my lord. Father-in-law and mother-in-law. Thereafter, my lord, the petitioner number, the accused number 1, that is the husband, Siranjit Poddar, he was arrested, my lord. He was subsequently enlarged on bail. After investigation, case has been succeeded under section 306, my lord, abatement of suicide, and section 4 of Dowry Provision Act, my lord. And in the search sheet, my lord, Lordship will find the search sheet as page 3, my lord. Annexure 3, page 20, my lord. Lordship will kindly come to page 21, my lord. The petitioner before your Lordship has been shown as a absconder in the search sheet. And the search sheet has been laid under section 306 and read with section 4 of the DP Act. Nando Poddar and Jivan Poddar are absconding from date of occurrence.
It was earlier rejected.
Lordship once rejected, my lord.
We'll have to have the CD then.
You did see.
It has already been succeeded, my lord. My only prayer is that, my lord, we are ready to, we have received the summon, my lord.
Since this court has already rejected once, how can we grant without seeing the?
It is during the course of investigation, my lord. Now we are ready to face the trial, my lord.
Oh, you were always ready.
The direction, my lord, that can be disposed of, my lord.
Can copy.
Can copy would be necessary. All right, lord.
May I please, your lordship? So this revision
But
petition.
did he want a direction to appear there? Did he want a direction to appear there? Is it committed already?
That scan copy will reveal, that is not.
All right, on that day we can do.
May I please, your lordship?
Yes.
Possibly this revision petition is the subjuditional judicial measure Bishwanath Chaile passed a judgment in an act case when he was directed to pay 15 lakhs to this respondent lordship. And subsequently we have filed an appeal also and it was appealed. In the meantime, lordship, we have paid 13 lakhs. We have come into settlement with the respondent lordship. We have paid 13 lakhs to him. So my submission is lordship, the conviction may be set aside. That's because we have arrived in a settlement lordship. And the amount has been paid to the respondent lordship.
Any affidavit or anything you have filed? Nothing.
Till now, lordship, we have not filed. If it requires lordship, we will file that because he is also there. He knows that.
Better you file something because
Lordship.
what if tomorrow somebody comes and says
Lordship. We'll file an external availability.
the prayer of learned counsel for the parties leads the matter again on so and so in order to enable them to file affidavit.
Deeply obliged, lordship. Definitely.
Affidavit regarding settlement of the matter.
I'm appearing on behalf of RKDC Lordship on actually Standing Council NCB. He's on legs, so Lordship this definitely time. For the time.
May I please, your lordship? My lord, this appeal under against the judgment and order dated 27/12/2024 passed by the learned special judge POCSO in POCSO case number 40/2023, convicting the appellant under section 10 of the POCSO Act and imprisonment for 7 years, my lord, with fine of rupees 10,000. Judgment order page number 16 to 47. Annexure 2.
Can copy of fees here also.
This is for suspension of sentence. I
Yes, my lord.
had learned counsel for the petition. Appellant. Scan copy because it's over, I think, this year.
Yes, it is.
This year, therefore, suspension of sentence and bail shall be considered after receipt of TCR. Main appeal, you write in view of order passed in connected IA number so and so list the matter again on.
Appeal is admitted, my lord.
Hmm?
Appeal is admitted, my lord.
I think we can do on the same day after it is received.
Lordship, matter will pass over for the time being, myself.
Lordship, this is statutory jail appeal.
All right. Pardon. Bill is admitted. Any private respondent is there? Call for the PCR. Please take it on.
Number 13.
Eight is allowed. There's an appeal against conviction, my lord. 5 years of sentence, my lord. POCSO is there, section 8. Appealed under section 8.
This would go, my lord.
Notices may go, my lord. Section 8 of POCSO is there.
Hard on counsel for the petitioner. Then we can then admit it. Issue note.
My lord.
Appeal is admitted. Issue notes to the respondent number 2. Steps by speed post with AD within 3 days. It's call for the TCR. There is IA also.
IA is also there, my lord. For the suspension.
This IA has been preferred seeking suspension of sentence. Bail. Same shall be considered on receipt of the TCR, which has been called for in the connected appeal. Again on.
File application. Date has been fixed, my lord.
15 June.
Deeply applied.
Number 10.
My pleasure, Lordship. Yes, Lordship, earlier the respondent said appeared, Lordship, in the missed case regarding delay. Now their name is not showing in office. That indicates that we have taken steps.
This has come up for the first time.
Yes, Lordship.
Appeal.
Appeal is first appeal.
Anybody's name is shown? No.
Yes, respondent's name is not shown. Earlier, Lordship, in the IA they appeared, Lordship.
They may have appeared, but unless their name is shown.
Lordship. Basically, Lordship, this appeal is earlier is the trial court, Lordship, allowed their petition section 138, and appellate court, Lordship, reversed the judgment and acquitted the accused person, Lordship. So this appeal is, Lordship, against the acquittal of the accused person, Lordship. And appellate court has
Advocate counsel for the petitioner. What is there?
I'm J. Kolita.
For them, there is no Akalanama.
I've been the main appeal of court number now.
This is the main appeal. Means case was there. Two A's are there.
Yes.
This condonation has been disposed of. Mrs. K. Bhattacharya, who is Mrs. K. Bhattacharya, is available. You could have informed them instead of waiting for notice.
His phone number is not with me. That is a problem. I will inform him. And so, if necessary, I will serve the extra copy of the chapter.
No, let's do one thing. You inform them. If they appear, then we'll record that and pass order.
That can be done. I'll try my.
Yes, we'll take a vote.
Obliged.
Mr. Lordship.
Well, in this case, my lord, I have been implicated. Only, my lord, one UA bill was found, my lord, in my farm's name. My name is not in the FIR. আপনার- হ্যাঁ? 37 আমার আছে, I'm sorry.
Our item, my lord.
Hmm?
37 is my item, my lord.
Yes.
Service completed, lordship.
Another credit is separated for the.
This is, this is
Charge
so,
sheet matter, my lord.
Matter, lordship. That scan copy was called for, that is a flag marked relevant pages, 183 statement of the.
so we can take it up.
Yes, ma'am.
It's about 6 years old.
He is behind bar for more than 9 months. ma'am.
The fact that he is a minor, her birth certificate.
Where is the FIR?
FIR is page,
Certificate,
page 14, my lord.
14 lordship, translated person. Below 6 years, lordship.
Has the trial started?
Yes, trial has been started, my lord.
Huh?
Yes, trial has been started, my lord.
Victim has been examined.
Yes, my lord.
Where is that?
I have mentioned in additional affidavit, my lord.
Hmm?
I have mentioned in additional affidavit, there is an additional affidavit, my lord. In paragraph 2, my lord. Q1 and PW2, my lord.
Specifically implicated the deposition as well as in her 160. The statement is found to be
And medical report also supports Lord.
Hmm?
Medical reports also support
Where is that?
that I have flag mark, Lordship. Are Heyman found to be
Flag mark where?
Lordship,
In the main file.
yeah. Lordship, the blue color flag perhaps, yeah.
There is no blue there in the record. Okay.
Abrasions also, Lordship. Private parts.
So everything is consistent. What is there for you? Nothing for you.
Okay, but only victim mentioned about touching only, my lord. That can advise be
Lordship, it's
section 10, my lord, which is a
We
lesser.
have to have regard to the age of the victim.
Sexual harassment is purely
How much
practice.
specifically she can say. Your medical report is very damning.
If section 6 may not be affected, my lord.
Because of ultimately trial. So why would it? The medical report clearly says insertion.
Yes.
So why should that not be attracted? Where is the earlier? Rejection order is there.
There is
Yes,
in
Your
page
Lordship, page
58.
58. Dated 9/1/2000.
Page 59. Huh? Yes, amicus, anything to say?
Submit one judgment. That's 14.
Actually, I forgot that amicus is there. Only when I was reading the judgment hard-landed amicus, then I realized. What is this?
Lordship, para.
That's okay, but he has not relied on any judgment as such. So that we need the aid of this judgment anyway. It's 59 to sense kori diba hai. After para 2, this is the second bail application. The earlier one having been rejected by order dated 09/01/26 in bail application 2904 of 2025. To paragraph 5. Paragraph 7. learned paragraph, next paragraph, paragraph 8. Learned amicus theory, Miss so and so has also submitted the same line as learned additional PP and has relied upon the decision of the Honorable Apex Court in X versus State of Uttar Pradesh and another 2026 SCC online SC 43. Full stop. I have perused the TCR. It appears that the filing of the charge sheet, the trial has been progressing, comma, the charge having been framed under section 6 of the POCSO Act. The deposition of the informant mother as well as that of the victim has also been recorded. I will not say on merits, having regard to the above, considering the gravity of the offense, the prayer for bail stands rejected at this stage.
Publishment.
Petitioners. In this case, my lord, my name is not FIR. When no CDR, no statement, nothing. I have been, my lord, only implicated that some EUA bill.
What was recovered?
Nothing,
Lordship,
nothing recovered from me, my lord. It is recovered from a truck. I am not the owner of the truck, not the driver of the truck. No connection, my lord.
Is 3,638.544 kgs of codeine phosphate, Lordship. Huh?
Who was arrested from the truck?
Two persons were apprehended, driver and
Taminur Islam
Yes.
and Sheikh Alamin.
yes, Lordship.
You are?
I am Ranjit Shah. Nothing in the FIR, my lord. Only my implication is that the notice under section 67 issued to me, my lord. I filed reply through my engaged counsel, but police did not satisfy my lord. On call, my lord, I appeared before the police station to assist the investigation. And then police taken me into the custody. And
Then-
thereafter charge sheet was filed, implicated me, my lord. Saying that the UA bill, my lord, which was issued to me, it is recorded in my farm's name, Mahashushila Agency. This is the only implication, my lord. So, my lord, in this regard, I am, my lord, written, my lord, details the reason how I have been implicated and how my.
During investigation, Lordship, the EUA bill and the invoice in question, that is in the name found, name of the GST number of the present petition. Name has been reflected
Disregard, my lord. I would
as
like
the
to
owner of
place
the invoice and bill number so and so dated 16/8/2025, which is that he has got some direct connection with the country. Established the very fact that the consignment codeine phosphate is procured the name of the present accused.
So what is your answer to that?
my answer, my lord. Page 4, para 4, my lord. I given details, my lord, reason how I have been implicated, my lord. May I read, my lord?
Frame, Lordship,
Read, my lord.
framed. Now the matter is fixed for the time of, for the evidence stage, Lordship.
At page 4, para 4, my lord. May I read, my lord? Para 4, 5, 6, 7, and 8, my lord. And 9. The GST documents I have annexed, my lord. UA bill I have annexed.
What, page 4?
Page 4, para 4.
This
Para 4, 5, 6, 7.
is not your explanation.
Yes,
It is just the.
My explanation, my lord, the petitioner is the only owner of the farm named Ma Sushila Agency. And in this name, GST IN is reflected. The UA bill issued by the Mira Trade Exim and Radha Agency in the name of the petitioner firms, for which the petitioner is suspected in the notice under section 67 of the Act was issued for appearance on 6/9/2025 to Messrs. Ma Sushila Agency, that is in the name of petitioner's firm. On receipt of the notice, the petitioner submitted the detailed reply containing his statement, my lord. That reply I have annexed 4. Now, my lord, the petitioner begs to state that despite submission of the detailed reply, the petitioner was called for to appear before PS. Accordingly, on bona fide reason and to assist the investigation, the petitioner appeared before police station. However, the police taken him in custody and forwarded him before the court on 11/1/2026 on the ground that the UA bill issued by Mira Trade Exim and Radha Agency clearly reflected the GST IN the Ma Sushila Agency, thereby establishing that the consignment of the cotton phosphate cough syrup was procured in the name of petitioner's firm. Now, my lord, kindly see my para 8, my lord. The petitioner begs to state that the contrabands were recovered from a truck which is driven by Shaminur Islam with the helper Shaikh Alamin. The truck was not owned by the petitioner. As such, the petitioner is not having the possession of the contrabands. It is alleged that during investigation, it is found that the petitioner's agency name surfaced as the owner of invoice number so-and-so dated 16/8/2025 connected with the goods/consignment question. However, the GST number used in the UA bill was registered in the name of Ma Sushila Agency, owned by the petitioner, for which he is implicated in this case. In this regard, the petitioner submits the following facts. Now, para A, my lord, page 7. That the agency named Messrs. Ma Sushila Agency carrying on a legitimate trading business within the state of Tripura under the petitioner's agency and is engaged solely on lawful trade consumer goods such as fortune products like sugar, soybean, so-and-so, my lord. Tripura Biscuits ICM, Saj Food Products Private Limited, Bask Farm, Arkanagar Industrial Growth Center, Agartala, Tripura, Incense Sticks, Agarbatti from Shiv Enterprise, Bardoel, Agartala, Tripura. Now that goods are ordered booked through officials means such as Bisk Farm under booking app Shazgus Product Private Limited and for others through my registered mobile number. And all transactions are carried out only through RTGS or NEFT banking transaction, ensuring full transparency and compliance with the GST and other commercial laws. The goods ordered the petitioner from the above mentioned company are delivered by those company itself to the destination within Tripura at its own responsibility. The petitioner's firm never engaged in trading, stocking, or transportation of any pharmaceutical or narcotic substances, nor have ever dealt with any cough syrup or medical products containing cotton phosphate or chlorpheniramine malate.
Yes, yes, go
Para
ahead.
9 minutes. That the petitioner begs to state that invoice in question is not registered by the MS Ma Sushila Agency, nor was any purchase made under its cover. The documents is a clearly fabrication designed to falsely implicate the petitioner that he is not involved in the offense as the corresponding invoice number MTE/2526/9886 so-and-so is not reflected in the official goods and service tax records of MS Ma Sushila Agency. This absence in statutory records serves the irrefutable evidence that no such transaction was ever undertaken by the petitioner's firm. That the petitioner begs to state that the MS Ma Sushila Agency operates strictly within the state of Tripura and does not engage in interstate purchase or sales. The alleged transaction, if interstate, is entirely inconsistent with the petitioner establishes business model or practices, further demonstrating the falsity of the accusation. So, my lord, my humble submission, my lord, these are the facts and circumstances. If somebody, my lord, used my number, it is not my control, my lord.
Charge has been framed against you.
Already framed.
These are pleas you should have raised during the stage of framing of charge.
Yes, Lordship.
That issue, my lord, my question is that, my lord, whether what are the materials against me which, my lord, attract section 37, my lord, of the These materials are not attract section 37, madam.
Consignment involves
So,
commercial
may I
quantity.
submit
lordship.
first, madam?
Section
May I
37
submit
will
first,
come into
madam?
play.
My lord, my humble submission, I would like to place these two judgment, my lord, three judgment.
Section 29 is also incorporated, lordship.
Under what basis, my
Your
lord? This
name
is
of your firm is what?
Messrs. Ma Susila
Not
Agency.
data agency.
So, my lord, it is not my control. Somebody used my number, my lord, and
It's a matter of
procure
trial,
something, my
lordship.
lord. How can I
It
can
is
be
a matter of
implicated?
trial.
My lord, I may be allowed to submit, my lord. Along with PP may be directed to at least submit first. So, my lord, somebody used anything which is not under my control. And if the police during investigation found this number is matched with my firm, my lord, I could have escaped, my lord. How I appeared before the police station? I submitted reply against the notice under section 67. Thereafter, police did not satisfy, called me. I appeared before police station. I could have escaped, my lord. Because of my bona fide reason, I know that I am innocent, my lord. So conduct is maybe regarded, my lord.
What is your business?
My business is this, my lord.
This
That,
Masusila, what do you do?
yes, my lord, that I have explained, my lord, everything. That, my lord,
Grocery items.
grocery item, para 7, my lord. Para 7, that para 7, para A, B, C, my lord. This is my business, my lord. The agency named Messrs. Smart Social Agency carrying on a legitimate trading business within the state of Tripura under its petitioner agency and is engaged solely in lawful trade consumer goods such as fortune products like sugar, soya basmati rice, poha, maida, suji, refined soya oil, etc. From AWI Agribusiness Limited, formerly known as Adani Wilmar Limited, Bojjunagar, Agartala, Tripura. Shops item like Lakshmi Sri, Bhandar, Netaji Subhash Road, Agartala, Tripura. Biscuits, items like Shaj Fruits Product Private Limited, Bisk Farm, Arkenagar Industrial Growth Center, Agartala, Tripura. Incense sticks from Agarbati, from Shiv Enterprise, Bardwala, Agartala, and Tripura. These are the my basically business, my lord.
The seized contrabands has been
I
recovered.
may be allowed to submit first.
You have already
You are
submitted.
continuing. I
You
have
already
never
submitted.
submitted. From first moment you are submitting always and interrupting continuously. Man.
Your name is Ranjit Saha.
Ranjit Saha.
Who is Jiban Saha?
Jiban Saha is not my lord. It is a part of my lord. That business, my lord. I have no connection with that bill, my lord. I am denying this.
I think this was, it appears this codeine phosphate was in these palm oil bottles.
Yes, that's what I'm going to submit.
So he was the grocer and
Dealer, Lordship, that has been recovered from a palm oil containers, Lordship.
If
That is from a
anything,
hidden
if
chapter.
anything done, my lord, that can be done by
Not
these
a
two
very-
persons, my lord. Those are involved.
Cleverly they
My,
have done the
my
jigsaw.
document, my number only may be used by them, my lord. My
Being the
document,
proprietor, Lordship,
my
he
number
has
may be used by
allowed
them.
persons to use his GST number, UA bills, his business identity has given for transporting, Lordship, all the contrabands. Thereby committing section under section
That
29 of
because,
can anybody else's GST number? Is it so easy?
my lord,
There must be
they
some
may,
process.
they may use, my lord, they fabricatedly, they may used to do their act, my lord.
whether to that
For
effect
which,
they
my
have
lord,
filed any
I
FIR,
being an,
Lordship.
I being an innocent, my lord, I appeared before police station voluntarily, my lord, on call to assist the investigation.
Whether to that effect they have
So, my
filed
lord,
any FIR
if
before.
at
the
all I
court.
was, my lord, involved, I could have escaped, my lord. Why I
You
appeared
escape.
voluntarily?
Where will you escape?
My lord, I could have, my lord, because this is going on is how in a case like NDPS, my lord, how I can appear. I appeared for investigation, my lord, for assisting investigation. Because police called him. Earlier, my lord, I filed reply, my lord, against notice under section 67. So my humble submission, my lord, if anything based on document, my lord, it will be, my lord, ascertained in due course of trial. Now, my lord, I am my lord, a person, my lord, with various ailment, my lord. My daughter is always crying, my lord, at home, my lord, who is
No
calling me. My lord.
consequence. 37 is there.
Yes, Lordship.
37 is not, my lord. I submitted, my lord, 3 judgment, my lord.
You appeared there and said what? You don't know.
I appeared before police station.
And said what?
Say these are the statement which I have made before your lordship, my lord. These statement I have made before the police.
When you were involved.
I could have escaped, my lord, if I at all involved, my lord.
You
There is
said
no
you
other
appeared
option,
very
Lordship, other way
innocently. You went and appeared, but you appeared and stated that I am doing this.
My lord. How, my lord, innocently a man can appear before police station where I have done that there is an evident danger is coming, my lord. How can this is my conduct may be considered, my lord, at least in this regard. Nothing, my lord.
Question is whether there is material or not. That is all.
This material, my lord, not at all, because I am in jail, my lord, since 11/1/2026. Almost, my lord, 139 days, 139 days in jail. So, my lord, my humble submission, investigation completed. Now trial is going on, my lord. I will face trial, my lord, each and every date. And these are the matter of documents, my lord. And that cannot be escaped. If at all, my lord, I am involved, my lord. Then, my lord, in the due course of trial, my lord, that can be, my lord, reflected before the trial, my lord, trial proceeding. And the learned trial court can decide, my lord, on merits, because except this document, nothing against me, my lord. These documentary things, my lord, there is no imminent danger that if I release on bail and I will do something which is very dangerous, my lord, that cannot be considered.
All right, we'll see. I have to go through the entire.
I have placed, my lord, some judgment, my lord.
Yes.
Yes, Sri Krishna Mohan Reddy and
Lord.
Tufan Singh and Kullalagu Ahmed Aramitta, my lord. My humble submission, I will face trial, my lord. This document will be verified at the due course of trial, my lord. At least, my lord, I may be reduced on bail on this. My daughter, my lord, who is, my lord, whose marriage, my lord, going to be settled, my lord. This is the another aspect, my lord, which I not, my lord, pleaded at my drafting, my lord. But this is the reality also, my lord.
Yes.
Always.
Bye.
Huh? I think it is mentioned. 14 mention one I 15 is. Sometime. Somebody's there? Somebody's there? Yes, supplementary list item 40, anybody is there?
Item 40. They have not received the steps from the service is not complete. Otherwise, CD is here.
CD?
Is here. But
As per office note dated 15/5/26, service notice has not been received in the concerned section. CD is received. CD received.
already, my lord, it was directed to be retained. So
CD was already received and has been retained. Have to take steps. Is taken on.
I return the CD or
June.
June.
If there is any investigation is to be made further, or is it?
My lord, I have found the 183 statement.
Alright, CD be returned and resubmitted in updated form.
Detail of episode দিব দাদা
Please, your lordship. Lordship, CD was called for lordship. It was on interim lordship. Last date I missed lordship. 27/2 lordship. The petitioner is on interim lordship.
I have received a CD is not up to date, my lord. Right, my lord.
A pending.
Last date also, that was the.
Yes, my lord. Last
I
date.
think it's a pending for a long time, lordship.
Seven, the earlier IO he was transferred, my lord. So whether after his interior state was recorded or not, that is not reflected in the.
Was not directed to lordship. 27/2 lordship. Was not directed by the honorable court to appear.
to do now? 25 matter pending for so long.
Yes, my lord. I have found, my lord, the last update, it was of 31/10/25. Thereafter, last update.
4326.
3/26.
In this case, what updation is required?
Because, my lord, that is regarding a goal, my lord, submitting a fake goal. As per last updation, my lord, that fake goal was still lying in the bank, my lord. That has not, because that has to be ascertained.
All right. Learned counsel for the petitioner, learned additional. If prosecutor submits that up-to-date CD is available. 27. Appears that by last order dated 12/5/26, the updated CD is directed to submit without fail by the list again also, and so communicate this. Furnish a copy of this order to the order Kaushik.
The interim may be
Interim order passed earlier.
obliged.
May I please, your lordship? Lordship, in this matter, we took steps to register post lordship, but service is awaited, lordship. Updated CD was also available. We may be allowed to take fresh steps for PPOP during the course of the day, lordship.
With service on respondents number 2 and 3 not yet complete, petitioner may take steps through police station by routing it through the registry list again on. So
My lord, here I may be allowed to return the CD. CD is not up to
CD to be returned and resubmitted the next date fixed in updated form.
19th. My lord.
May I please, Lordship? Lordship, this is a delay petition, Lordship. Delay of 519 days, Lordship.
Jail appeal.
Lordship.
Objection, I suppose.
Jail appeal.
Applicant. Done an additional 50. This is an application for condonation of delay of many
519 days, Lordship.
is in preferring connected jail appeal. There are the reasons for the delay have been stated at paragraph
8, 9, and 10,
8,
Lordship.
9, and 10 of the instant IA, which I have perused upon such perusal. Before that, right, learned additional PP submits that state has no objection. Full stop. There are having regard to the above, I am of the view that the petitioner was prevented by sufficient cause from approaching the court in the period of limitation. Accordingly, the delays instance disposed in the main appeal registered.
Like, Lordship.
None appears for the petitioner or respondent. Affidavit in opposition has been per office dated 30/01/26, which is available on. List the matter again on in June for admission.
In the connected criminal appeal against acquittal in NIA case, Lordship, leave petition has been preferred, Lordship. Appeal file under section 419 of the NSS. Dear Lordship, sign is not disputed by the accused, and moreover, the witness also deposed that witness, that is the brother-in-law of the accused, deposed that accused may have borrowed money from the complainant. At this time, Lordship, paying for having the leave petition so that the appeal may be heard.
But why come to the High Court? Couldn't you have appealed before the session judge?
Lordship, I understand, Lordship, the Celestium judgment, as per Celestium judgment, there are two options, Lordship, 413 and 419. But Lordship, that option is, in my humble submission, is on the appellant. And moreover, amount of the check is only 1 lakh. So with the leave, she has preferred before this honorable court, and she has approached for legal aid. Because actually, in all humble submission, I want to submit that she wants to avoid one letter, Lordship, because definitely they will prefer appeal again before this honorable court and against any order of the session, Lordship. So she wants to exercise her option by preferring appeal directly under section 419, for which a leave has been sought under section 419(4) of BNSS. Options are there, Lordship, 413, 419. Amount of the check is less.
Option is also with this court to grant or not to grant.
Definitely, Lordship, I understand, Lordship.
Especially since there is a provision there.
Yes, I understand, Lordship, I understand. She has approached for legal aid and amount of the check is less.
All the more reason not to come to the High Court.
Because against any order of the session, there would be again an appeal.
How? There is no scope for second appeal.
Acquittal, Lordship, take.
No scope for case of conviction. In case he is convicted in appeal. This is acquittal, isn't it?
Acquittal.
So if convicted, he will come in appeal. If it is reversed in sessions court.
Yes.
Assuming you had preferred a regular appeal.
Yes.
The sessions court. You succeed, then he will come in appeal in the High Court.
Yes.
That is what you are submitting.
Yes.
So by entertaining it directly, why should we take away his right of appeal before the High Court? Why should we force him to go to the Supreme Court? Yes, what is your submission?
There is specific provision to approach the learned session code. It has approached the session code. Otherwise, I have no objection in the leave petition, but as there is statutory remedies available to them to approach the session code, so they should have first approached the session code here.
Otherwise, you have no objection.
As specific provision is there, so they should have approached.
Because you don't go to that sessions court.
They appear before the session code if they approach the session code. Then we will get another opportunity on it.
Sure about what your stand is. Don't make alternative state. Otherwise, you
I
have
have objection here.
Lordship may kindly peruse Lordship Celestium judgment, Lordship.
yes. Where is
Celestium
that?
judgment.
Haven't read it in a long time.
Yes, para 7.8, Lordship. Para 7.8. 7.8, it is at page 21. Page 21 below. Two paragraphs I will read, Lordship. Page 21. May I read, Lordship?
Yes.
In the case of an offense alleged against an accused under section 138 of the Act, we are of the view that complainant is indeed the victim owing to the alleged dishonor of a check. In the circumstances, the complainant can proceed as per the proviso to section 372 of the CRPC, and he may exercise such an option. And he need not then elect to proceed under section 378 of the CRPC. Now, Lordship, para 9, Lordship. These are the two options. Para 9. In the circumstances, we find that section 138 of the Act, being in the nature of a penal provision by a deeming fiction against an accused who is said to have committed an offense under the said provision, if acquitted, can be proceeded against by a victim of the said offense, namely the person who is entitled to the proceeds of a check which has been dishonored in terms of proviso to section 372 of the Code of CRPC as a victim. As already noted, a victim of an offense could also be a complainant. In such a case, an appeal can be preferred either under proviso to section 372 or under 378 by such a victim. In the absence of the proviso to 372, a victim of an offense could not have filed an appeal as such unless he was also a complainant, in which event he could maintain an appeal if special leave to appeal has been granted by the High Court, and if no such special leave was granted, then his appeal would not be maintainable at all. On the other hand, if the victim of an offense, who may or may not be the complainant, proceeds under the proviso to section 372 of the CRPC, then in our view, such a victim need not seek special leave to appeal from the High Court. In other words, the victim of an offense would have the right to prefer an appeal inter alia against an order of acquittal in terms of the proviso to 372 without seeking any special leave to appeal from the High Court only on the grounds mentioned therein. A person who is a complainant under section 200 of the CRPC who complains about the offense committed by a person who is charged as an accused under 138 of the Act, thus has the right to prefer appeal as a victim under 372 of the CRPC. So, Lordship, from above we can see it is an option on the victim or the appellant to prefer under 372 or 378. 378 was always there, Lordship. It is only by celestium judgment a victim has been given an option that he can also avail the remedy of appeal under 372. Here in my humble submission, the appellant would like to prefer, and definitely, Lordship, leave is the discretion of this honorable court, Lordship. .372 is an additional option given to him, and 419, that is 378, was always there. Seventh line, para 9 is absolutely clear, Lordship. In such a case, an appeal can be preferred either under proviso to section 372 or under 378 by such a victim. 378 is 419, Lordship, now, BNSS. Or statutory? Right, Lordship.
So alternative is there, but right under the proviso to 372 is a much stronger right because no leave to appeal is required there. As a matter of right, you can appeal.
Definitely.
But an appeal under 378(4) is a risky right because court may refuse you leave.
Definitely, Lordship.
Is it not?
Definitely.
Where is the judgment impugned? Signature is not disputed.
Lordship.
Signature is not disputed.
Signature not disputed.
There's some disputed facts here in that case.
Signature is not disputed. The accused says she has not given the check directly to me. She says the accused says she has given the check to her brother-in-law, and the brother-in-law has given it to me. That is her only contention. And my case is that she is a debtor. She gave the check to me through her brother-in-law.
I guess there are some disputed facts here. There are two cases filed on the same day against the present accused petitioner and against the brother-in-law of the accused. Across of this case, the complainant admitted that both the cases are from the same transaction. And the transaction was only 2 lakhs, Your Honor. Already 2 lakhs were paid and that case was has already been withdrawn, Your Honor.
There are two checks, one amounting 2 lakh, one amounting 1 lakh.
And
Against 1 lakh, Lordship, they have the accused is a different person. That is the brother-in-law who has now accepted and he has paid the amount. And in respect of 1 lakh, Lordship, this is the particular case, Lordship. And against 1 lakh, accused is the sister-in-law, not the brother-in-law. Two different checks. Different cases, two different transactions. So this 1 lakh is still unpaid.
No money received, and there is no any statement in what mood she had paid the money to the accused. There's nothing here.
Anyway, when the signature is admitted, the presumption arises, burden
Presumption
shifts to you.
We have rebutted that presumption, Your Honor.
How?
They rebutted by the process of PW1, Your Honor. We have also adduced evidence, Your Honor. The presumption was rebutted by us, Your Honor. We have succeeded in rebutting that presumption, Your Honor. Yes, initial presumption is in his favor, but that presumption is not alone sufficient, Your Honor. He must have to adduce cogent evidence before the Honorable Court to corroborate that presumption, Your Honor. Yes, she failed
No,
that evidence, Your Honor.
no plausible defense has been raised by them. In fact, the brother-in-law, he has said that the accused may have borrowed money. He says like that. And even at one place, if your lordship peruses the appeal, at one place, the accused has in fact admitted. The accused has in fact admitted. Page 56 of the appeal, lordship, she has in fact admitted. She says it is not a fact that I do not owe 1 lakh to the complainant. That means she owes 1 lakh.
So we have disputed that line, Your Honor. We have not said like that. We have disputed that line, Your Honor. And if Honorable Court read the entire.
What is there to dispute? If the line is there, it's there. If it's not there, it is not there. It is about evidence, isn't it?
From the very beginning, we have disputed that we have not issued any check, Your Honor. We have not any, we have no any liability, Your Honor. From the very beginning, Your Honor.
On one hand, you say signature is not disputed, and on the other hand, you say you have not issued any check.
We have issued check to my brother-in-law, Your Honor. He has issued the check, Your Honor. Himself admitted in the court that the check was issued to me, Your Honor. And even if you peruse the paragraph 1, Your Honor, the complainant himself admitted in this appeal, Your Honor. Herself admitted in para 1, Your Honor, that we have not issued the check directly to the complainant, Your Honor. But as this is a leave petition, Your Honor, as I have no such statutory right, Your Honor, to object the leave petition, Your Honor, not argue on the merit of the case, Your Honor, at this stage. There is no other record, Your Honor. Cross-bar is very vital, Your Honor. Only the judgment is available before your lordship, Your Honor.
The appeal, it is there.
We are only considering the leave part. There is an arguable case to be heard. Heard learned counsel for the petitioner, the IA, learned counsel appearing for the sole respondent. This IA has been preferred seeking leave to appeal against the order of acquittal passed by the learned court below. Not sole respondent, respondent number 2. Learned additional people presenting the state respondent. So take a look at DD. Having heard the learned counsel for the parties at some length, it case to grant leave to prefer the connected appeal accordingly. Leave is granted and I stands allowed. Registry is directed to register the
Copy of the appeal may be directed to furnish.
copy of the appeal memo be furnished. Has been furnished
Furnished, Lord.
to learned counsel for respondent number. Please না লাগে আর করব রেজিস্টার করা পিছর করব
Masam.
Deeply obliged. Dear Lordship, my name is not shown, Lordship. Delay was condoned on the last occasion. I do not have a copy of the appeal also.
Nothing, they come in next week, sir.
All right. Third learned counsel for the petitioner, Mr. So-and-so appears for the respondent number 2. You furnished
Lordship, I will during the day of
copy of the appeal be furnished to learned counsel for the respondent number 2 in the course of the day. This is what delay has been condoned already. I think this is main appeal. Appeal is admitted. Call for the TCR.
So in I, dear Lordship, regarding the leave, but this is also Lordship appeal against acquittal. Take up them on the next day, Lordship.
So we have to take up the IA first. I thought IA was for suspension. I didn't.
No, the I was for Lordship leave.
This is also NI.
Lordship, and here Lordship in the trial court Lordship convicted the accused person Lordship, but the appellate court reversed the judgment and acquitted him Lordship. So there is against Lordship appeal against acquittal.
Okay, then we passed the same order
Lordship.
we passed in the last case.
Lordship, in submitting appeal may not be required, Lordship, because this is under 430.
Leave
Lordship. They have approached the court where the appeal ordinarily lies.
Statutory appeal.
Lordship.
And why leave to appeal petition is there?
Earlier the process was going on Lordship. Earlier,
Not required, Lord. After
before this
celestial
celestial,
judgment,
yes, before
It
celestial.
says this IA not required.
Lordship, I mean appeal may be had.
Learned counsel submits that since this is a statutory appeal, the IA need not be pressed. Accordingly, the IA is dismissed as not pressed. Baki appeal to hetu already jitu dilu hetu likhi for the TCR.
Fix a date for admission hearing Lordship.
Again for on so for admission.
Lordship. Obliged Lordship.
Admit boli nalage likhibo tenehole.
Lordship,
Third
can it be
so-and-so.
next Monday?
Call for the
So
TCR.
difficult. Monday or Tuesday? Monday. 15 June. Not important. Deeply obliged.
May I please, my lord? My lord, this is a criminal appeal, my lord. There is a delay of 119 days, 119 days. Notice were issued, Your Honor. Third, Your Honor. There is a- Flag not for-
Services is complete.
Yes, my lord.
Heard learned counsel for the petition and learned additional PP. For office note, service on respondent number 2 is complete, however, none appears. Accordingly, who is appointed as yes. Isn't the respondent number 2? Extra copy we furnished. Because paste again on.
Obliged.
You are there. Is there any list for amicus? Huh? You are there. Anybody present? No. Yes.
Yeah, please, Your Lordship. Lordship, in respect of respondent number 2, there is no, my lord, service report.
With service, my lord.
Hmm?
Service report, it is,
What is this matter?
Sir, my lord, a quashing petition for quashing of the proceeding.
Against?
Yes, proceeding, which is pending at Subjudicial Magistrate Court in the district of Sonitpur. My lord, kindly,
Who is respondent number 2?
wife. Respondent number 2 is wife. My lord, in this case, what happens?
We have to wait for service then. You cannot do dusty service.
That can be done, my lord.
Service on her learned counsel petitioner and learned additional PP service on respondent number 2 is not yet complete. Petitioner is permitted to effect dusty service on respondent number 2 and file affidavit.
One
accordingly.
problem is that, and that petitioner is now deployed at Siachen, so there would be some problem, my lord. He is defense personnel.
Said yes.
I would take, my lord, first step.
Then through police station,
Yes, my lord, that can be done.
instead of dusty service, through concerned police station, routing through the registry. Please take it on.
Obliged, my lord.
Item 8.
Hmm?
Recently, appellant is convicted, Lordship. Appellants are convicted under section 20 B2C, Lordship. Statutory appeal, Lordship. I am the legal aid counsel for the appellants, Lordship. NCB is other side, Lordship.
Who appears for NCB?
RKB Chaudhary.
Is not available in court.
Available, my learned PP has made a mention in the morning.
Where?
For one, sir.
The petitioner are convicted, Lordship, for a punishment for 10 years, Lordship. And they have already undergone 8 years, Lordship, 20 days, as on today, Lordship. There is a petition.
Otherwise, this is a statutory appeal, but only the question of suspension of sentence is concerned. That we can consider on another day. We can admit the appeal. Is it not?
Or Lordship may take up the matter at 2, Lordship.
Don't know about 2. If the list is.
That's last item.
Hmm?
Item also.
Yes, okay, till call up last.
Yeah, please, Lordship.
Right
Lordship,
here.
I have a instruction to withdraw this appeal.
Just paid for by. Matter is. Is withdrawn.
Not only miscase, Lordship, appeal is also.
Main appeal you write that. Miss.
Appeal is not yet numbered, Lordship.
It is not yet numbered.
Numbered.
So if miscase is dismissed, appeal, no question of appeal.
There is a instruction, Lordship.
Hmm.
From the jail, there is a instruction that I have submitted those papers.
Why, he has already completed his term or what?
Almost completed, Lordship.
Right? Hard. Anjali Dekar, learned legal aid counsel, appear. Applicant, appellant. Copy of the letter. And by the appellant to the Secretary, High Court Legal Services Committee has been furnished, seeking withdrawal of the case. The ground that the applicant convict is nearing completion of his sentence. Accordingly, prayer has been made for leave to withdraw the IA stroke appeal. Prayer is allowed. IA stands dismissed on withdrawal. Keep the letter dated 11/2/26 as part of the record. Yes.
A copy may be forwarded.
Copy of this order be forwarded to the Superintendent Central Jail for onward service to the applicant.
Let's check.
Yes.
Lordship, this IA 91125 is petition for Section 5 of Limitation Act for condonation of delay of 115 days. Opposite party number 2 has already filed their reply. I'm looking for short accommodation today. Counsel is not present today.
Counsel for?
Counsel for the petitioner, R. Senso.
This is against what, NI?
NI.
Huh?
NI.
Appeal against acquittal?
Appeal against acquittal.
This is for leave to appeal, is it?
Yes. 3925. Next week. Next week, if any date possible.
No, this is for delay condonation. The other is for leave to appeal, is there?
Leave to appeal.
So which will come first?
Delay
or
condonation.
leave?
Delay condonation.
You have filed objection to the delay as well. What is your cause of delay?
Lordship, medical grounds, and since the case was from Tinsukia, so the procurement of certified copy and giving it to us, so there was some considerable delay in that part. So mostly is related to that. Lordship, and
And your objection is with regard to?
Lordship, they have not properly explained the delay, Lordship. But thing is that, Lordship, they have 3 months time to get the certified copy of the order, Lordship. Thereafter, they took 2 months time to get the opinion from the advocate, Lordship. And thereafter, Lordship, they have annexed one medical prescription, Lordship, where it is mentioned, Lordship, only 2 weeks rest.
3 weeks.
3 weeks rest. But thing is that, Lordship, from May 2024 to they took, Lordship, almost 4 month time, Lordship, to file this, Lordship. That is 4 months is not explained, Lordship, anyway.
Let him come then. On the request of for the petitioner. The matter again on. So your name is shown?
Yes, Lordship, A not.
Yes.
Any
date did you?
5th June. Much of you.
Lordship,
Yes.
Lordship, in this matter, this is a criminal petition for questioning of the proceedings which are currently pending before the learned SDJM Jorhat. So in this matter, on last occasion, this matter had come up on orders. Now already the TCR was called for, and TCR is already with the court, scan copies. So praying for listing this matter under the admission hearing, Lordship, a short date, Lordship.
Service on respondent 2 is complete.
Yes, respondent to service on respondent 2 was taken up. Whether it is completed or not, it will be reflected on the office note, Lordship.
Boys and their names.
Received by wife of respondent number 2 as per process server's report. Sufficient, I think.
Lordship, may fix this matter for admission hearing, Lordship, since now it is long-term matter, Lordship.
Mr. Learned counsel for the petitioner also to ensure learned APP appears from office note that service on respondent number 2 is complete, but none appears. TCR has scan copy of TCR has already been received. Hence, is the matter for admission on
Any short date, Lordship, a fixed date, Lordship.
9 June. Okay. Yes, 9 June.
Lordship, any day, a short date, Lordship.
Yes, 9 June.
Obliged, Lordship.
None appears list again on. Did you? Yes.
Yeah, please, Lordship. This is a condemnation petition, Lordship, 111 days delay. Already steps has been taken, Lordship.
Jail.
Lordship, jail appeal, Lordship.
It hard. IA has been preferred seeking condemnation of delay of how many?
111 days, Lordship.
7 days in preferring.
Explanation at paragraph 8
jail
and 9.
appeal. Reasons for the delay explained. That paragraph
8 and 9, Lordship.
which I have perused. Learned additional PP has no objection to the prayer for condonation. Having regard to the above, I am that the delay in preferring the jail appeal has been sufficiently explained. Hence, the delay stands condoned and the highest stands allowed. This is directed to register the appeal. Yes.
Obliged, Lordship.
Wait, please, your lordship. Lordship, in this case, lordship, POCSO case, this petitioner was arrested, then released on bail. Subsequent lordship, he is a defaulter lordship. Thereafter, lordship, we were asked to take step upon this respondent number 2 lordship. Accordingly, in the month of March, lordship, we have taken the step, lordship. Now, lordship, service report is there, lordship.
Where?
Whether that is, they have to confirm, lordship, whether service is completed or not, lordship.
Not complete.
Because already 10 months in jail custody for the default in 2 or 3 days lordship appearance. Otherwise, lordship, victim statement already been examined, lordship.
So you served by police station?
That we already taken, lordship. In my,
no, I think only usual process you have taken. Okay, you have taken, but still then Yes, PP.
Lordship will take instruction, Lordship, service.
As per office note, service report on respondent number has not been received. Learned additional PP to take instructions as tapes have been routed through the office of the public prosecutor. Release the matter again next week. Date.
Highly applied.
Yes.
May I please, Your Lordship? In this case, my lord, appeal against the appeal against the conviction order, my lord. TCR already come, my lord, and I is for, my lord, bail, my lord. 5 years conviction, my lord. Already 110 days he is in jail, my lord. Conviction under section 21B, my lord, and 29 NDPS Act, my lord.
Section you filed? Section?
TCR be called for, it's
They already come, my lord.
Lordship, we do not
Uh-huh.
5 years imprisonment, Lordship.
You are not required.
Written objection is not required.
Any oral objection?
Go through the TC. Admission hearing.
All right, had learned counsel for the petitioner and learned additional PP. TCR has been, LCR has been received. PP press for time to go through the same. The purpose of the IA for bail. IA separate bail.
Lordship.
And bail. List the matter again on.
Please, Your Lordship. As per office note dated, my lord, neither ready nor answered notice has been received from respondent number 2, my lord. But my lord, postal journals are also not available on record, my lord. So matter may be sent before my lord Lazima court for appropriate. So we have taken by speed post, my lord.
What is the necessity for going to Lawazima court? It is already
My lord,
recorded that you have taken steps, but notice has not been received back.
my lord, because my lord, Lazima court will pass appropriate order, my lord, after considering the postal journal, my lord. Because we have taken by speed post, my lord, and it is almost 2 months, my lord.
You could have submitted the postal report.
My lord, that may be, my lord.
Where is this respondent address?
That is, my lord, under Mukalma police station, my lord, Nalbari district.
And take through office of PP. Reports are also not always very reliable. Shown also.
My lord, since there is no interim, my lord, till today, since there is nothing interim till today, my lord, we are regularly appearing before the
Have some urgency, my lord.
Already had learned counsel for the petitioner. Need additional PP as per office note. Service. Respondent number 2 is not received back service report. Although petitioner has taken steps by speed post with AD. Consignment tracking report is also not available. Let's place the matter before the Lawazima court. Reaction.
May I please, your lordship. This IA is preferred for condition of delay of 51 days. The criminal revision petition, lordship, against, it is a petition under domestic violence proceeding. Prefer this revision, there was 51 days delay, lordship. The
Sorry, I got a little distracted. What is your submission?
lordship, this IA for condition of delay of 51 days. And this criminal revision petition filed against this domestic violence proceedings, lordship. And
What about steps? Steps.
steps, today's motion date, lordship.
Is motion. Orders.
Only, lordship. Last date.
Because IA is there.
Yes.
Had learned counsel for the. IA has been preferred, seeking condonation of delay of 51 days. Preferring the connected revision. You have got copy? Learned additional PP. Here's for respondent number 1 issue notice. The remaining respondents. Steps within 3 days by speed post edit. List again on.
Hello.
Wait, with Lordship. Lordship said 4194 petition, praying for leave to file an appeal against judgment dated 28/11. That's a appeal against equity, Lordship. First by the Honorable Chief Judicial Magistrate Shivsagar in NI case number 5 of 2022. The appeal has not been registered yet. It is an IA. For leave to file an appeal against judgment, Lordship.
He has been preferred, seeking leave for preferring against the order of acquittal.
Acquittal.
Passed by the learned court below. To notice to the sole respondent. Steps by speed post. 4 weeks dated.
Date may kindly be fixed, Lordship. Well, obliged.
Here,
Steps.
State of Assam has preferred an appeal against equity lordship. Right? Leave petition. POCSO lordship. Has been an order dated by equating the respondents' clauses. Graduate section 9 and 10 of
Had learned additional PP. This session has been preferred seeking condonation of delay of 188 filing the state appeal against acquittal. Issue notice to the respondent. Steps as per usual process within 7 days. Is taken on.
I has been condoned.
No notice.
Item 8.
Yes.
Out of Lordship, petitioner were convicted under section 22B2C, Lordship, and their sentence for
You want
imprisonment.
to say something?
I thought the delay petition.
They already condoned, Lordship. In IA 362.
He's confused, so let's have this on Monday.
Lordship, delay has already been condoned. Thereafter, this appeal has been registered and
IA is there for
Yes.
suspension.
suspension of sentence, Lordship. Statutory appeal.
Lordship, but for that, this one is there, no? For bail, Lordship, we need to file some we'll file our objection.
Learned counsel for the petitioner, IA. Learned counsel appearing for the state respondent 6 file objection. The matter
38.
again on. Today we
Bless that.
And appeal may be admitted thereafter June for consideration of IA.
connected appeal with a hard learn. So appears for state respondent. Suspension of TCR to আহিব লাগিব to suspension.
Out of Lordship 10 years, they have already undergone 8 years to 1 month, Lordship. Almost
For
one third.
For receipt of the TCR, if we give it next week, it will not come. I has to be considered after TCR.
Obliged.
Aforesaid, yeah.